sexual behavior of your daughter. You elbow your daughter on the right side of her face. Also grabbed hold of her sweatshirt collar and pulled her shirt approximately halfway down.
This case involves Ms. Harper, who was charged following a domestic incident with her minor daughter in Wexford County in November 2025. Law enforcement responded to a family dispute that escalated into physical contact, during which officers observed visible marks on the child.
This is case number 25-4847 SM. Appearances, counsel.
Courtney Lawrence on behalf of the people.
Robert Martell from Ms. Harper joins me to my right, Your Honor.
And we are here for a final pretrial. Is there any resolution to this matter?
There is, Your Honor. It's my understanding that it will be pleading no contest between out of counsel with jostling, and in turn will be dismissing count 1 domestic violence.
That's correct, Your Honor. The reason for the no contest is potential civil liability. She does have an ongoing CPS investigation. We're concerned there would be overlapping with some of the admissions.
Are we able to sentence today?
Yes, Your Honor.
All right, Ms. Harp, have you heard what the attorneys have said the resolution of this case is?
Yes, Your Honor.
And is that how you wish to resolve it?
Yes, sir.
I need you to speak up if you would.
Yes, Your Honor.
Will you please raise your right hand as best as you're able? You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth. So it's my understanding that you'll be pleading guilty to an added count. I'm sorry, no contest. I'm sorry. You'll be pleading no contest to an added count 2 of disorderly persons jostling. That is a 90-day misdemeanor and or a fine of $500. In exchange for that, the domestic violence will be dismissed, which is the 93-day misdemeanor and or a fine of $500. Now, the reason given for the no contest plea is because potential civil liability, and there's some concern that a plea in this case might be able to use against you in a CPS case that's currently pending. Do you understand that in order to accept a no contest plea, the court will be asked to review a document, it looks like it's going to be a police report, to determine whether or not there's enough of a factual basis contained in that to find you guilty and to use that for sentencing purposes? Do you understand that?
Yes, sir.
Do you also understand that by entering a no contest plea, you are essentially accepting the responsibility of being guilty without saying that you're guilty?
Yes, Your Honor.
Is that your full understanding of the plea agreement?
Yes, Your Honor.
Back on November 14th of last year, were you on probation or parole?
No, sir.
Were you on bond?
No, sir.
Do you remember reading and signing the advice of rights form in this case that talked about your rights to an attorney and your rights to a trial?
I do, Your Honor.
Did you understand those rights?
Yes, sir.
Most importantly, do you understand that that you have a right to a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
Yes, Your Honor.
Other than the plea agreement, has anybody promised you anything in order to get you to plea today?
No, sir.
Has anybody threatened you in any way?
No.
And is it your own free choice to plea today?
Yes, Your Honor.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, no.
No, Your Honor.
Then Ms. Harp, to the allegation that on or about November 14th, 2025, in the village of Mesick of Wexford County, how do you plead to count number 2 of disorderly persons jostling?
No contest, Your Honor.
All right. Counsel, I've been provided what's marked as plaintiff's exhibit number 1. It's a Wexford Sheriff's report number 83-2502120. Ms. Lawrence, are you moving for its admission?
Yes, Your Honor.
Mr. Hartel?
As are we, Your Honor, yes.
All right, People's 1 is received. The court was apprised that this was going to be a no contest plea, so I have taken the opportunity to review that report prior to taking the plea. Do counsel believe do counsel believe People's Exhibit number 1 forms a factual basis in which to accept the plea and the court rules been complied with?
Yes.
Yes.
As does the court. I find the plea is knowing, voluntary, and accurate. Harp, I find you guilty of disorderly persons jostling. In particular, I find that People's Exhibit number 1 makes out that back on November 14th and 25 in the village of Mesick, deputies responded to a situation in which it was discovered that there was some concern about maybe some sexual behavior your daughter may or may not be getting into. An altercation ensues. At some point, you elbow your daughter on the right side of her face. Also grabbed hold of her sweatshirt collar and pulled her shirt approximately halfway down while yelling at the time. Law enforcement also observed a red mark on your daughter's face. I believe those facts do make out the allegations for disorderly jostling. I also find the interests of justice are well served in allowing the defendant to enter a no contest plea, as a guilty plea could be used against her in a CPS case. Any elocution, Mr. Hartel? I'm sorry, is there any victim input, Ms. Lawrence?
It's not there.
Any elocution, Mr. Hartel?
Yes, thank you, Your Honor. I'd ask the court to consider this being time served, fines and costs without any probation or additional jail. I won't overly allocute anything. My client's only under privilege, in part because it is under privilege, but also because it would defeat the point of a no contest plea. The court did mention this is potentially going to be used against her in CPS investigation. Would be very careful on walking on eggshells. But I do know the court did read the report. So what I will say is, if I just read this report and I'll go from there as if it was that way, I would interpret that as a mom who probably meant well, who maybe did things the wrong way or too enthusiastically, and after spending 33 days, if I recall correctly, in jail, has had plenty of opportunities to realize there's better ways to go about things. Society has rules for a reason. I'm part of society. I need to obey those rules. And again, I'm walking on eggshells for a reason, but I would ask the court to consider time served, fines and costs. I believe that's appropriate based on the totality of the circumstances. I realize this was the jostling, not just serving the peace, but there was allegations of physical contact, and we respect that. And I know there was a finding as well. Thank you.
Ms. Lawrence?
Thank you, Your Honor. I am going to ask for additional jail time. I do think there's probably some underlying issues here, maybe involving alcohol. If the court remembers, the defendant was on bond and did horribly. I'm not sure if I can even count the amount of bond violations she had. And that's what got her remanded to jail in the first place. If I believe correctly, that was on the 7th, so I think she does have a little bit of credit. But I would ask the court to impose not a long jail sentence, but a short jail sentence with credit for time served, as I do think it is appropriate in this case. I don't think Ms. Harper is a good candidate for any type of supervision, to be honest. I think she proved that while she was on bond, and I think it would be appropriate in this case.
Ms. Harp, I know you entered a no contest plea, but you do have the right to address the court. Is there anything you'd like me to consider before sentencing?
That I do regret the tonight in question, and I know there's no excuse for my behavior, and my supervision was failed horribly. I would like to say to the court that it was not because of alcohol use. Alcohol use is no longer an important part of my life. My granddaughter died on August 8th in a car accident, 3 years old, to an alcoholic driver. I am not concerned with using alcohol, Your Honor.
If I might, Your Honor, I wasn't sure if she'd want to put it in there herself, but she has informed me that there is an eviction process that's been started, and she would like to get home to that. I know that's not the only thing the court factors in, but ask the court to factor that in if there was a teetering on the fence of releasing her or not. Thank you.
Ms. Harp, had you been consuming alcohol on that day?
Yes, on that day, Your Honor, I had.
How much had you had to drink?
I would say a half pint or less. That's what I purchased, was a pint.
Have you ever done treatment or anything?
No, Your Honor. I mean, I did I had a disturbing of the peace years ago, and I did whatever the court had required of me. I believe it was AA meeting.
In your past, I show in 99 MIP, minor in possession. In, I believe it's 11, a disorderly drunk, and 17, another disorderly drunk. And you were on probation for at least one of those?
Yes, Your Honor.
And you also look back at the file, and it looked like by my count, there were 14 bond violations, mostly dealing with missed tests and failed to reports. Defendant currently has 32 days of jail credit in this case. I am going to do a period of probation. I'm going to do probation for 12 months. I think that's appropriate given the defendant's past with disorderly conduct, and the fact that alcohol was involved. So during that 12 months, you're not to violate any law, report as ordered, not leave the state without permission, and to commit no new crimes. You are eligible for early release. Well, you're not because of the domestic component, so you'll have to serve that full 12 months. During the period of time that you're on probation, you are not to consume any alcohol, no illegal controlled substances, including recreational marijuana. You'll be subject to testing pursuant to the terms of your probation officer. Any counseling that your probation officer feels is appropriate. Some parenting classes, anger management, and any additional programming is appropriate. There is a $75 Crime Victims' Rights Fund fee, $50 state minimum fee, $150 fine, $150 court costs, $150 attorney fee. 12 months of probation is $360. Because of the 32 days that you have sat in jail, I'm going to credit you back $150 of that towards your fine. Any balance that remains unpaid for more than 56 days will have a 20% penalty added to that. I'm going to waive that penalty, though, while you're on probation. All right? At some point today, you'll be released from the jail. So 32 days jail, 32 days credit. At some point, you'll be released from the jail today. If that's in enough time, you'll have to get over here and get signed up for probation. If it's not, though, you'll need to report first thing in the morning. All right. Ms. Lawrence, I should have asked about the no contact order.
The people don't take a position on that, Your Honor.
Ms. Harp I assume CPS is working towards reunification. Where are things at in that process?
I've not had any contact with CPS. Her father has had contact with CPS.
All right. I'm going to leave the no contact order in place, but I will allow it to be lifted pursuant to the probation officer. All right. Thank you.
Under Section 750.170 of the Michigan Compiled Laws, the court accepted a no contest plea to disorderly persons jostling, a misdemeanor offense carrying a potential jail term and fine. The original domestic violence charge was dismissed as part of the negotiated resolution. The plea structure was specifically chosen to avoid admissions that could be used in a pending child protective services matter, which the court recognized as a valid legal consideration. After reviewing the police report and finding a sufficient factual basis, the court entered a conviction on the jostling offense. Sentencing was guided by the defendant's criminal history, repeated bond violations, alcohol involvement, and the domestic context of the conduct. The court determined that supervision was necessary and that unsupervised disposition would not adequately address public safety or compliance concerns. Pursuant to Section 771.1 of the Michigan Compiled Laws, the court imposed 12 months of probation with mandatory conditions, including abstinence from alcohol and controlled substances, testing, counseling, parenting classes, and anger management. Financial penalties were assessed under statutory authority, with partial credit applied for time already served in custody. The court ordered that the no contact condition remain in effect, subject to modification through probation, while child welfare proceedings continue separately. This disposition reflects the court's focus on supervision, accountability, and compliance rather than further incarceration.